So today we're going to discuss these cases and the family leave article, and then that'll be it for today. You don't have a quiz. This was your quiz for this week. So um, hoping everyone will get 100 for that, so you don't have anything else to do for this week except for to listen and finish out discussion what we're doing in class today. Next week, again, one more new unit. We'll have a quiz for that, and then that'll pretty much be it. If you need to make up anything or retake quizzes, email me. That will be available to you through Monday the 14th. And all right, let's talk about the Bostock versus Clayton County case. So where did this case come from? What state did this case come from? Georgia. Very good. And thank you, Joe. This is one that I chose a few years ago when it was brand new. I think your article says it's new, but it's about 5 years old now. Decided in 2020. Are we in the federal system or the court system or the state court system? What are we now in? We're in the federal. That's right. Why? How do we know that? Because we're at the U.S. Supreme Court. That's exactly right. Remember, that's in the federal court system. So this case, even though it involves a Georgia citizen suing a Georgia employer, it involves a federal law, so it was brought in federal court, and it worked its way all the way up to the United States Supreme Court. What is the law that we're dealing with in the Bostock case? Very good. Title VII of the Civil Rights Act of 19... See, y'all are just firing answers at me this morning from reading these cases. It's beautiful. It's music to my ears. Title VII of the Civil Rights Act of 1964. Very good. And remember that Title VII prohibits discrimination on the basis of race, sex, national origin, color, religion, those sorts of things. Title VII is not the only anti-discrimination statute. Remember, we have other ones like the Americans with Disabilities Act that covers disabilities, the Age Discrimination Employment Act that covers age, and so on and so forth. I'm not ever going to test you on which ones cover which. Just want you to know that there are more than one federal anti-discrimination law, and they establish a whole constellation of protected classes, of which sex is one. So this one involves sex. So this obviously was passed, I think you've already said, in 1964. So what is the question before the Supreme Court in the Bostock case? What's the question that the court has to decide? Jevin.
Does the act protect against sexual orientation or sexual preference?
Knock that out for me. All right, that's right. Does the law protect discrimination on the basis of, say it again? Sexual orientation, that's right. So what does the actual law say? What's the wording in the law that says that it's illegal to discriminate on the basis of sex? Does it actually say orientation or transgender? It doesn't. So that's the question before the court. Does that law that was written in 1964, the way it's written, does it prohibit discrimination on the basis of sexual orientation? Excellent. So that's the question before the court. What had happened at the lower court levels? Who won at the lower court levels? Mr. Bostock or Clayton County? I think Clayton County had won initially, because up to that point, the precedent was that courts interpreted Title VII to not cover sexual orientation. Knock that out for me real quick. All right, so here we are. So this is actually, I think your article tells you there were 3 cases that were combined into one when they got up to the Supreme Court. A couple of them covered sexual orientation, and one where an employee was fired for being transgender. So the court said this is really all the same analysis. It's the same question, same issue. We're going to combine those together. We're going to do one opinion that applies to all 3 cases. I think that maybe I asked you a trick question a second ago. One of the reasons the Supreme Court took this case and combined them was that they had gotten different, that the lower appeals courts had given different answers. I think one of the cases that came up, the appeals court agreed that Title VII did bar discrimination based on sexual orientation. Bostock's particular case, he lost, and the courts agreed with his employer. So one of the things the Supreme Court can do is they can say, well, if we've got these decisions out there that are conflicting, that are different, we need to take the case and make a rule on it so that everybody knows what the law is from here on out. We don't have these conflicting decisions. The way the court framed the question, and Jevin was absolutely correct, the court must decide whether an employer can fire someone simply for being homosexual or transgender. The court then says what the court almost always says. When we're interpreting a law, we're first going to look at what it says, right? What the text is, what the plain meaning of the law is, what that word would have been understood to mean and encompass and include at the time it was written. 1964. What does the dissent or the disagreeing judges, what did they say about what that word meant in 1964? What did they think? Would it have been commonly understood in the 60s that the word sex would include things like orientation and transgender? Probably not. I mean, that's what the dissent's point is. That wasn't really mainstream, or at least solidified enough in the public consciousness that that's what we all would have assumed. Oh yeah, of course, sex, that means these other things. The majority opinion, though, how do they deal? They give a great example in the case of why they think this is just on its face, simple discrimination based on sex. They said that if you take two employees, one female employee and one male employee, they're both attracted to men. You fire the male employee for that reason, but you don't fire the female employee for that reason. The majority says that in and of itself right there is just basic, fundamental facial discrimination. You've treated one person differently than another person, and the only difference between them is their sex. One's a male and one's a female. You wouldn't fire the female for that reason, but you fire the male for that reason. That's how the court kind of justifies and comes up by saying that if we read this word sex, there's no way to get around it. So this whole argument about, let me skip to something real quick. The dissent, the disagreeing judges, do they say that they think that sexual orientation and gender identity should be covered under Title VII? I mean, they don't disagree with the majority that ought to be protected. The dissenting judge's argument is what? Ryan.
That it's not currently in the law and it's not up to them to put it in the law.
Bingo. It's not what the law says. And if the law needs to say that, whose job is it to write it into the law? Congress. That's right. That's not our job. Judges, Supreme Court doesn't write laws. We can interpret them. We can say what we think they mean. We can say whether they're constitutional or not. But our job is not to make law. And the dissenting judges are saying, should Title VII cover sexual orientation and gender identity? Yeah, we think it should. But it doesn't the way it's written. And if it does cover it, Congress should do that. Right. going back to the argument that if we look at that word sex at the time that Congress wrote the law, it would not have been sort of commonly understood that that's what it included. So the dissenting justices are not saying we should be able to discriminate on those bases. They're just saying it's illegal the way the law is written. They even bring up the fact that in the year before this opinion came out, Congress had before it a proposed law that would have amended Title VII to spell out that discrimination against orientation and transgender identity is covered. But what happened to that law? It didn't pass. So the dissenting justice's point is not only is it Congress's responsibility to do that, they had a chance to just last year and didn't. So what else could that tell us but that they don't want it in there? That's their argument. This is an argument that is pretty common if you read Supreme Court cases and you get down into the nitty-gritty. There's always a disagreement between the judges who subscribe to the theory that we should update the law, that it should be living, that we should update it with the times, much the way that the majority in this case did. And there's always a set of justices who believe in textualism. Our job is only to read the law as it's written and as it was meant at the time it was written, period. And there's always been this tension and a debate between the judges who are very faithful to the word of the law, the textualists, and the judges who are more about updating laws and bringing them into the current time. And you see that here. What I think is funny is, as a student of this, sometimes the judges will flip on whether they're an originalist, a textualist, or whether or not they're an activist, depending on how they want the case to turn out, right? They don't agree with the majority, so they're going to say, oh, you're doing what? You're making law. You're legislating again. It's not our job. But when they want the law to be changed and updated, like Justice Gorsuch does, he goes some pretty good lengths to be able to say, oh, this is what it always meant. There's no way it can mean anything different. We're not rewriting it. This is what that word means. And the dissenting justices, one of them in this case says, it's fine if that's what they want to do. They should just admit what they're doing, right? You're making new law. Just admit that you're legislating. That was their point. This is another example of the way that the law does evolve over time. And that if you brought a case in 2019 and you allege that your employer violated Title VII by firing you because of your gender identity, you would lose. Because before that, the precedent and the way the law was interpreted was that it did not cover that. You brought a lawsuit after the Bostock case, you'd win because the law has changed now in the way that the Supreme Court has said that's how we read this law. Now, Congress could have gone the very next day after this case came out and passed and amended the law and said, we specifically exclude transgender and sexual orientation from this law. Title VII does not cover that because that's what Congress does. I mean, they write the law, they change the law. They have the ability to do that, and that was the point of some of the justices. Congress can do all that anytime they want to. It's been 60 years since they passed this law. They've had plenty of time to update it if they wanted to do that. So that's kind of how we got where we are. Thoughts on this? Anybody, what was your impression, thoughts, takeaway from this case? What stood out to you? Anything? Ethan?
Pretty sure it was Bostic, but his employer saw that he joined a gay softball team, so that's how he got fired.
That's how he got kind of outed and fired? Yep. That's certainly not related to his work at all. Something he's doing in his private life. Softball's not really an activity that reflects negatively on your employer, like maybe if you had OnlyFans or something, you're wearing your Clayton County polo shirt and your other stuff. Not necessarily. What other takeaway? What do you think about this case, Xavier?
I think it was just interesting. I'm from Clayton County.
You're from Clayton County?
Yes, I'm from there. So just seeing how it was kind of back then, it gave me a different viewpoint and perspective on just how things were different, really. Because
You're from a discriminatory county, right? Is that what you thought? I'm just kidding. I'm just kidding. Just kidding. Other thoughts? Tristan, what's your thought? Any takeaways on this case? Well, that's fair. My folks from other countries. Samir, Camila. What do y'all think? Did it surprise you that before 2020 that sexual orientation or transgender was not protected in America? No? Didn't surprise you at all? Do you know in your home countries whether or not that's protected? That's fair. Passed in 1964. And now it's being read as of today in a totally different way. Madison, what's your thoughts on this case? Who was surprised to learn that orientation was not protected before 2020? Some folks surprised to learn that? Never really thought about it? All right, good thoughts. Let's move on now to Clark versus Champion. So, Clark versus Champion is also a discrimination case. Different law, though. What law are we dealing with in the Clark case? ADA, which is the Americans with Disabilities Act. Excellent. All right, so tell me a little bit about the plaintiff in the Clark case. That'd be Charles Clark. Who was he? What was his deal? Who wants to tell me about Mr. Clark? Ethan.
He was a type 2 diabetic, and he fell asleep on his job and got fired.
All right, that sums it up pretty good. He was a type 2 diabetic, fell asleep on his job, and he got fired. What other details about Mr. Clark did we find interesting? McCray.
Some things I thought were petty. They had a grooming thing where you have to be clean shaven.
Yep.
He tried to say that his diabetes made it where he had dry skin and shouldn't have to shave.
Right. He asked for some accommodations. So did the employer dispute that he had diabetes? That's really not in dispute. Everybody agrees that he did. He asked for some accommodations that he got, and some he didn't. What were the ones he asked for and got? Alexis. Right? And they gave him that. The refrigerator stores insulin. Y'all, this is like night and day. Everybody has the answers today. I love it. Yes. Yep, he asked to be able to go to doctor's appointments, and did they make that accommodation? Yeah, pretty much every employer does that, right? I need to leave today. I got an appointment. Okay, those were good. What else?
He asked if he would be allowed to not have to tuck in his shirt because he had shoulder
All right, he wanted to not tuck in his shirt. What'd they tell him on that one?
They said no.
He ended up saying no to that one. What else? Somebody mentioned the shaving already, I think. Who brought that up? Ethan.
He received accommodations for fridge insulin and time off, but nothing in request of loss of consciousness.
Okay. So really one of his accommodation requests was I need to be able to fall asleep sometimes when I'm at work, right? I mean, essentially, he's saying you fired me for that, and that was part of my disability, and I need to be accommodated for that. So one of them was I need to be able to sleep on the job. Did the employer accommodate that? No, they fired his ass for that. What about, and we skipped over the shaving, but I think we may have covered it. Did they approve or not approve for his shaving? They didn't approve it. Tried to bribe him too, though, didn't they? Yeah, and the homeboy turned down 50 cents an hour to shave every morning. So, just as an aside, haven't we all worked with somebody like Charles Clark? Just impossibly difficult. A victim of everything, needs an accommodation for every reason. I feel like I know him well, even though, of course, I don't know him. All right, so he did ask for some accommodations. When he sued Champion, he alleged some different types of discrimination. What all did he throw in? We've talked about that he threw in that he didn't get accommodations for his disability. So he alleged that. Harassment, that was good, that he was harassed on the basis of his disability. That was one. Another one that he was fired because of his disability. So we've got the lack of accommodations, the fact that he was fired, harassment, and then he also alleged retaliation. That your case doesn't spend much time talking about his retaliation claim, but it is, remember, against the law to fire somebody because they've made a complaint. So he did go to HR and make the complaint about the accommodations, and so he feels like part of the reason he was fired was retaliation for that. All right, good. So those were our facts. Did Champion fire Mr. Clark the first time they caught him sleeping on the job? No, they gave him another chance, right? So what went down on the day that he finally got fired? How'd that play out? Ryan?
More than one person saw him sleeping.
Okay.
Took a photo of him sleeping and sent it to someone else.
All right, they sent it to somebody on up the chain. And what was the person's reaction when they got that picture of him sleeping?
To message back, perfect, let him go.
Perfect, let him go, right? And that's exactly what happened. Mr. Clark woke up that morning, it says, claims he didn't remember coming to work, that he just woke up there and that he went to the hospital. And then his feelings got hurt because nobody from work did what? Called to check on him to see if he, really was sick or what had happened since he'd gone to the hospital. He did get a phone call, but it was to tell him that he didn't have a job. All right, so that's the facts. So if we move to the part of the opinion where court discusses the application of the law to those facts. So remember a couple of weeks ago, in discrimination cases, you might get to court and the employee has direct evidence of discrimination. I got a smoking gun. My evidence from looking at it on its face proves that I was discriminated against. In other words, we don't have to make any inferences. We're not having to read between the lines. We're not having to infer anything. So you can do that. If you don't have direct evidence, you go a different route, which we'll get to in a second. The court first evaluates Clark's direct evidence of discrimination. What did he think his direct evidence of discrimination was? What was his smoking gun piece of evidence he thought he had? It was that email that said, perfect, let him go. All right, so the court says, he thinks that's direct evidence. Let's evaluate whether or not that's direct evidence based on some other cases we have. All right, we've got a case, the court says, we've got this Portis case where there was direct evidence, where the supervisor told the employee that she wouldn't be worth as much as the men would be, and that she would be paid less because she was a woman. Just direct evidence of discrimination. We don't have to read between the lines on that. Okay? They cited an example of ETN, a casino employee who was African American, and that person was told by the hiring person that their skin was too dark and they were too black. So again, direct evidence. We don't have to read between the lines to infer anything about that evidence. They also gave example in an ADA case, the Rodriguez case, where the employer admitted that they didn't give the job to the employee because they had diabetes. Direct evidence. So the court says, let's evaluate those cases against Mr. Clark's direct evidence. What was it about Mr. Clark's direct evidence that they said did not make it more like those other cases? What was faulty about his direct evidence?
The eczema and shoulder surgery, they said that wasn't from diabetes, it was from that. So,
Close, yeah. His accommodations were denied because they weren't diabetic related. But the direct evidence he said he has was the email that said, perfect, let him go. What's wrong with the perfect, let him go email as compared to that other stuff? There's nothing, it doesn't mention his disability, right? It's not directly connected to his disability like you're going to be paid less because you're female. So if you wanted to rewrite, if you're Clark and you want to rewrite that email to be good evidence for you, to be direct evidence, how would you rewrite that email? I mean, obviously you can't do that, but if you're Clark, what do you want that email to say?
set it up to where they say something about his diabetes.
Yeah. So, perfect. His diabetes is finally giving us a reason to let him go. Let that diabetic SOB go immediately. Right? Link the decision to the disability, and that might be direct evidence. That doesn't mean that they're going to lose the case. We're just talking about what kind of evidence the plaintiff can present. So the court says, no, Mr. Clark, you don't have any direct evidence, but that doesn't mean you're out of court. You still have a chance to make out your case through indirect evidence, which is how most discrimination cases go, because we talked about this a couple of weeks ago. Most employers don't say, I'm not hiring you because of that diabetes, like that Rodriguez case. It doesn't happen most of the time. In fact, most employment disputes are something bad happens to an employee and they think it's because they were discriminated against, and the employer is always going to say it's something performance or non-discriminatory going on. That's most of our employment disputes. So in those cases, the plaintiff can still bring a case without direct evidence. They have to come to court and say, I have a circumstantial case. I think I was discriminated against. In that case, remember the burden shifts. The court asks the employer, well, he doesn't have direct evidence, but he thinks he was discriminated against. Tell us then what is the reason that you fired him or demoted him or took action against him. What was your reason? In this case, what was the employer's reason? What reason did they give, Janeway?
He was asleep.
Okay. He was asleep at the job. They said it has nothing to do with your disability. We fired you because you slept on the job. That's a violation of our policy. It's a terminable offense to be asleep on the job. It does not have anything to do with your medical condition. So when that happens, remember, then the burden shifts back to the employee to prove that that is just a cover story, that it's a false story, that it's pretext, that the real reason was discrimination. It's what happens when you don't have direct evidence. You go the other route. So the court's taking Mr. Clark's case through that route. All right, and they say, let's look at the accommodations you were denied. And we've covered that pretty good. I think you made the point, Ethan. They weren't, the ones that you were denied were not related to your disability. But the court also is very careful to say, all right, when somebody has a disability and they need an accommodation, we're going to look at whether or not that person has a disability. Was that in dispute? Nope. Was he qualified for the job? Yeah, he was qualified for the job. He did the job. There weren't really any, there were some complaints about it, obviously, but he was not a person who was unqualified for it. The key on an accommodation is that you have to show that you're able to perform the job with or without the accommodation. So the accommodation he was asking for was to be able to sleep on the job. Could he perform the job with that accommodation? Not really, maybe a little. But could he perform the job without that accommodation? No, he couldn't do the job while he's asleep. There's no way that accommodation would allow him to do the job with or without it. So the court's saying it's legal to say no to an accommodation if the person can't do the job without it. It's there to help a person do a job, to accommodate them to be able to do a job, not to do it for them or to take the place of a duty. So the court finds no discrimination on the accommodation part. They also said that when it comes to the reason he was fired, that they did not find any link between his termination and his disability. So his discrimination, his firing case claim failed. It then moves to his harassment claim. So let's talk about that for a second. The court says in order to prove harassment based on disability, it must be sufficiently pervasive and severe to alter the conditions of employment to create an abusive working environment. We talked about this a couple of weeks ago. That could be done several different ways, right? You might have a single comment that by itself is so bad, so offensive, so abusive that it could be said one time, and that would be harassment. We can think in our minds of just the most horrible things a person could say, and that might certainly be enough to constitute harassment. But we can also think of maybe a little comment here or there that's offensive, in poor taste, inappropriate, but doesn't rise to the level of just something that's just automatically harassment. But if it's said enough over time, if it builds up, it accumulates, if it happens over and over every day, that might rise to the level of being severe and pervasive. So the court's saying we're not making any bright line rules about how many times it has to happen or anything like that. We're going to look at each instance and see, is this a situation where whatever happened, whether it was one time, 3 times, or every day for a year, does that rise to the level of being severe and pervasive? So when they apply that test to Clark's evidence, his evidence basically of being harassed was what? I didn't get my accommodations, right? How did the court view the denial of accommodations as being harassment or not? How'd they evaluate that? Why was it not harassment, I guess is a better way to ask.
Because none of the accommodations that he denied were directly related to his...
They weren't directly related. The court says when we read those emails, it's a discussion between an employer and an employee about policy. There's a disagreement about what the policy is, but we don't see anything harassing in there. It's okay you can disagree with somebody without harassing them. So the court's saying we just don't see anything that rises to that level. And then I think Ethan made the point earlier. Even the doctor's letters and a lot of the medical stuff that he provided never mentioned diabetes. It mentioned some other conditions, but never mentioned diabetes. All right, so that is how the Clark case went down. Thoughts, impressions, takeaways on Clark? Ethan.
Says he even admitted he couldn't do the job and he was unconscious. So I mean, he basically kind of contradicted his claim.
He did. He torpedoed his accommodation claim when he admitted he couldn't do the job without it. without the accommodation. Other thoughts? Daquan, what'd you think of the Clark case? He didn't really want, he wanted to get paid, right? But that's why I say if you've ever had a job, everybody knows somebody like Charles Clark, I feel like. Ryan, what was your takeaway?
I feel like the way that case went, he was probably ignoring his legal counsel.
So I agree with that observation. I think that I don't know. I mean, I don't know exactly the whole story, but that would be a case where you would probably tell somebody up front, you don't have a great case. I mean, you were sleeping on the job. There's not much I can do about that. But there's enough to go to the Supreme Court. Tegan, what do you think?
This one went to the Supreme Court.
Oh, it didn't. Ryan's right. I'm sorry. This did not go to the Supreme Court. This was the Court of Appeals. Say that again. He was doing too much. Too much wrong? All right. What do you think, Jevin?
Yeah, I would agree. I think he was a little overblown.
A little over? That he was making too big a deal out of it? Okay. Good. Who else? Did you have your hand up?
I think what the worst looked on him at the end was that he was a manager.
He was a manager, and in fact, he was responsible for training people in company policies, one of which would include you can't sleep on the job, right? that wasn't a good look for him either. All right, other thoughts about this one? Gio. Say that again.
Because, like, the perfect let him go, he could be like, oh, they just body formed me to be let him.
That we're fine. He's been a pain in the ass. We're ready to let him. I mean, this is just enough.
Not everybody's gonna say perfect let him go. It's like,
Okay, that's an interesting take. So Gio thinks that the retaliation claim was probably better than these other ones. I did edit this opinion. I cut out a bunch of it. I may have cut out some of that. I'm not sure. But you're more sympathetic to him on the retaliation claim than maybe the others. Well, it does. I mean, it does. It's pretty clear to me that they wanted to get rid of it. And once they found a legitimate non-discriminatory reason, they jumped on it. And that's not illegal, but it does, as an employee, that would make me feel like these guys are out to get me. You know, I mean, they don't like me. There's something going on. Why are they coming after me? And so that's good evidence for him, you say? I think if I was HR, I would have at least made sure that he didn't go to the hospital for some diabetic emergency before I fired him for being asleep. Because what if it was a diabetic coma or something he had slipped into? I think.
It said he woke up after like a minute.
Yeah, he woke up. I think they were like, no, this guy, we know his deal. That wasn't diabetes. We've seen it over and over. But I'd have been worried about that. Yes. So it might have hurt him that this was something that he never asked for before. I could also turn that around and say he never complained before. And once he started complaining, what happened? He got fired. That sounds more like retaliation. But that's a very good point. You did great on this job for 10 years without sleeping at your desk. Yeah. Yeah. And maybe he did. Maybe I've edited that part out or something. But that's exactly the kind of analysis and thinking that I want y'all to go through. And exactly the type of analysis and insight that we will only get when you have read the cases and come to class. So that's y'all are really proving a good point for me this morning. Yes.
Well, I mean, he can do all the retaliation and all that, but him being like the manager of company policies, that's just
Yeah.
You can sleep on the job.
Yeah. I mean, I think the best argument against retaliation is we didn't fire you when you made any comments. We only fired you once you slept at your desk. That was what we fired you. How can you say it's for something else when you're ignoring that you went to sleep on the job? I think it was a bad look. The facts certainly weren't great for him. All right, let's talk for a second about the family and medical leave article. So hopefully by now you've read this article and you know from what we talked about in class that the United States, through federal law, through the Family and Medical Leave Act, gives employees 12 weeks of leave per year that's unpaid. You're guaranteed, remember, to come back to a same or similar job, that sort of thing. But the article points out that we are an outlier when compared to most developed nations in that they give paid, most of them give paid leave, and a lot of them give it for longer. So my question to you is I'd like to know either your thoughts on that, but specifically, if you wrote the law, if you were in charge of it, what do you think it ought to be? Paid or unpaid, longer, shorter? Would you do it? Would you do a percentage? I'm like, how would you make it up if it was you? I'm starting here, Ryan. You start us off.
Oh no. How much do you want to be taxed?
How much do I want to be taxed? I started with the accountant. All right. I don't want to be taxed.
I mean, money doesn't just evaporate, so you need to get it from somewhere.
Okay.
And if you're trying to give somebody more benefits in their job that is not directly related to the performance of the job, then it's usually going to come from the employee's pay in the end, really. It'll be part of your benefits. And what you're actually being paid will be less. So you're paying for it either way.
Okay.
So do you want to pay for it now or you want to pay for it up front?
Do you think it should be paid or unpaid?
Paid or unpaid? I think unpaid would be
Unpaid's the way it is now.
the more effective route.
Okay. And you're looking at it more from an analytic,
Because it'll be you will have the money that you would.
you're not looking at it from necessarily a moral standpoint or what it ought to be. You're looking at it more from a straight numbers financial way it ought to be.
Functionally, it will work better unpaid.
Gotcha. All right. Good perspective. What do y'all think? Other thoughts? Should be paid, Gio? Should be paid, and how long? Now, a lot of companies do offer paid maternity leave. They're just not required to by law. So the law only requires that you give 12 weeks unpaid. Everybody has to do that. Some places will give paid maternity leave and all that, but you would make it mandatory paid. Okay. Maybe half while you're out? Okay. Alexis is nodding. Are you on board with that? All right. Everybody here is an employee who needs leave. Does everybody want paid leave? Yeah. All right. Now everybody here is the owner of the company. How do you feel about paid leave?
If you want paid leave, get a salary job.
It depends is my favorite answer in this class. What does it depend on?
Maternity leave, like you gotta have a good reason why you're off. I mean, don't we all get?
Yeah, well, the Family and Medical Leave Act now, it gives you the reasons. Having a baby, being sick, having a sick family member, caring for a kid if the spouse is on active duty, adopting a kid.
I know at some teachers, in some states, they get paid during the summer and they're not teaching, they have to make their paycheck stretch. So they tend to get paid less, so they get paid their salary, but they get paid through the month.
Mm-hmm.
And the
So you would look at maybe a percentage of salary or something like that rather than your whole salary. I would bet that some countries set it up that way where you're not entitled to 100% of your salary, but everybody's entitled to like a certain minimum, and then employers could go over that if they want, but I bet they set a minimum. All right, well, so Janeway is pointing out that we can look at paid leave in isolation, but you can't really do that because it may be getting paid for in other ways through taxes and other things like that. And so, yes, do we want paid leave? Sure. Do we want higher payroll taxes or however else we're paying for it? No, maybe not. There are a lot more considerations than just should we be paid while we're out and how long.
I thought it would be beneficial because if you look at it, all the statistics, like a lot of people, we all know somebody that was like, oh, I was sick, I was in the hospital for a substantial amount of time, and I didn't have enough money to pay my bills.
Mm-hmm.
So now I'm homeless and that third. So if you are able to have that pay to at least help out with those payments while you're sick, it would one help with the poverty rate, two help with homelessness, because at least you're getting something to sustain yourself enough doing that.
So as part of the social contract, basically, of the country and society, that you want to provide a basic subsistence level to keep people from slipping into poverty, homelessness, and all these other things that come along with that just because they couldn't work. The cynical view, of course, is people will exploit the system, right? That people are going to get a job and they're going to mark on their calendar when they've been there 1 year. And as soon as they've been there 1 year, they're figuring out what they can put in for leave, right? The cynic would also say, if I get 12 weeks of paid leave per year, how many weeks of unpaid per leave for every year do you think I'm going to take? All 12. Why would I not take 12 weeks of paid leave, right? If I get it, I need to figure out a reason to take it. That's the cynical view of it, is that, why would I let a year go by and have worked for 12 weeks when I could have just taken them off and made up some
You're paying taxes to
reason?
Be there, why would you not take it?
Well, that's right, depending on where it's coming. So that would be the thought. Any other thoughts on the family leave article? Was anybody surprised that other countries do more than we do in terms of paid leave? Say that again, Gia. Yeah, were you surprised? I think a lot of it depends on the perspective of, and you guys have done a great job of articulating that, the perspective of an employee versus the perspective of employer, perspective of society as a whole.
When I was in Germany, there were people that were exploiting the medical system. You hear other people complaining about it because they're doing something that they shouldn't be doing, but they were pretending to go to the hospital. They were going to the hospital for reasons that were not necessary for them to go to the hospital, or even remotely necessary, to get time out of work. And it would work out in a way where they would be out of work paid more of the year than they were at work paid.
See, that's
And that happens a lot.
That's the argument against paid leave in a nutshell. Yeah. Is it? I agree. That's the tension. I think
you was the problem.
Star.
It was a lot.
Like the last sentence you said.
Gio or Ryan? Ryan, say your last point again.
What I just said?
Mhm.
That it was
About the exploitation. There was a lot of people in Germany that were doing it.
It was not just a few people that were doing it. It was a lot of people that were doing it.
So that the tension between saying, well, we can't ever 100% make sure if people aren't going to take advantage of it, if it's just a few people, but it's for the greater good. And I think your response was a lot. It was not just a few. I think it would take some reflection by social scientists and economists to look at what other countries have done and then kind of assess, was it a success, was it not a success, what were the unintended consequences, who actually paid for it, did we see a reduction in homelessness and that kind of thing, did we, what happened in those countries who did it.
I feel like even if they do that, it's kind of, it won't really be accurate in terms of putting that data to the American society, just because of how that society, like Norway or Sweden, like how they have like a socialist economy, how their economy was built from the very ground up around them.
All right, so you have hit on something that I agree with.
Yeah, like you can't really put
I don't know that you can apply these other countries to the Americans' behavior. That's one of my biggest hangups is I'm so skeptical of the American culture and mindset that we would, like, I think immediately everybody would be like, I get 12 weeks off every year. It'd be crazy if I didn't take that.
I was gonna bring up the socialist point as well, but I was gonna say, with, what's my point? Come back.
You're good. That is a great point. I think culturally
In America, we just have an idealistic point of view. So,
we have,
individualistic.
and it's hard to,
Versus other countries, which is more societal.
I think some other countries are more homogenous, and we are, it's hard to think of a consensus here.
That reminded me of what I was gonna say.
Yeah.
You were asking if we were surprised. I was not surprised at all because we're like more or less like a collectivist kind of society.
Mm-hmm.
We're also like a little tribalist.
Yeah.
You know what I mean?
Yep.
There's a lot less of like, because like pay leave is like kind of, when you're not at work, other people are paying for that.
Mm-hmm.
And we're very like, kind of stick to our groups.
Yep.
We don't want to help other groups a little bit more.
That's a great insight, Jay. I agree with you.
Yeah.
Totally agree with you. Whereas, as if the whole country is socialist and our entire thing is built around socialism and everybody's bought into that and it's just kind of what we do, that it is hard to compare, to your point, that with our experience, which is, to your point, is so varied and not common necessarily, and individualistic and proud of that, and that kind of thing. So I thought that was a really interesting article, and that's excellent discussion. Y'all, I really appreciate everybody coming today and participating the way you did. You do not have another quiz this week. You're good for this week. We'll start something new next Tuesday, and then we'll do that for 1 week. Then the next week we'll review, and you'll have your exam. So y'all are almost there. Get your interviews and all that stuff done.
Message saying that we